Okay. We were talking about polygraph techniques, and we're going to be talking about all these bad people and how we're trying to get them to confess. And actually, one of the problems with getting people to confess is we get false confessions. So we're going to talk about that as well. There's a limitation to concealed knowledge. Wait a minute, that's not where I want to start. I want to start here. Okay. Polygraph's accuracy. How accurate is the polygraph test? We talked about this last time. Examiners err when they believe that a liar is truthful. It's a false negative. Or that a truthful subject is lying, and that's known as a false positive. Advocates of polygraph procedures, including polygraph examiners themselves, claim very high rates of accuracy. And they will tell you that, by God, they're the best polygraph person in the world, and they get 100%, or 95%, or 99%, 99.9%. But that's not true. And we're going to see the accuracy rates in just a second. Scientists who have reviewed the accuracy of CQT control question tests concluded that it could discriminate lying from truth-telling at rates just barely above chance, though far below perfection, of course, but it is above chance. So yeah, they are accurate to some extent, but not always. The test cannot distinguish emotions such as fear, anger, nervousness, and excitement. We talked about this last time. All it's doing is it's measuring emotion, but it really can't tell the difference between any emotion that raises your heart rate. And of course, anger, nervousness, and excitement all raise your heart rate. And actually, it's all it is reading is your heart rate. It also is reading how much skin conductance you have. But of course, all those emotions will change that as well. Questioning methods are not standardized, of course. Deceptive subjects can be trained to beat the test by taking countermeasures to avoid detection. And I will teach you in just a minute how to beat a polygraph test. You're welcome. Even the most vocal critics of polygraph acknowledge that the technique has overall accuracy somewhere around the 65% range. Okay, so that's it. So 35% of the time, they're inaccurate. Polygraph tests are most valuable at investigatory stages of a criminal prosecution, and as a way to encourage confessions from the suspects against whom other incriminating evidence has been gathered. This is the time you should use a polygraph test. Evidently, this is a handheld polygraph test. I don't know anything about it. I've never seen one of these things, but I kept getting pictures of people with this thing in their hands. I haven't seen it myself. There are two ways in which polygraph results can be used in criminal cases. In about 1/3 of the states, a suspect takes a polygraph test with the understanding that the prosecutor will drop charges if the suspect passes the test, but may use the results in court if the suspect does not pass. In about 1/3 of the cases, 1/3 of the states, that's the law. I was looking this up before I came to class today, trying to find that list of 1/3 of the states. Every state has different laws, as it turns out. 2/3 of the states you cannot use polygraph in a court of law. And one of those states is California. So you may think that you can't use polygraph tests in a court of law. Everybody wants Cheetos today. Okay. You may think that because almost all of our television comes out of California. And what doesn't come out of California comes out of Utah. And what doesn't come out of Utah and California comes from Canada. And Canadians don't allow polygraph tests in a court of law. So for that reason, most of the states, or all the states that televise things, don't allow polygraph tests. But there are 1/3 of the states do allow polygraph tests. So before you commit a crime, you need to figure out what state you're in and what their laws are as far as polygraphs are. So just a thought. Sometimes suspects take polygraph exams at the urging of their attorneys who want to make sure that they are telling the truth. Of course, attorneys don't know. And it really doesn't make any difference as far as the attorney is concerned, because the attorney still has to be your attorney. everybody deserves a legal counsel, right? No matter how guilty you are, you still deserve legal counsel. Defenders often provide positive test results to the police, of course, but your attorney cannot, if you are guilty and he knows you're guilty, he can't tell the police that, because that's client-attorney privilege, whether he is your attorney or not. If you give him a piece of information, if you ask him to be your attorney and you give him the story, he cannot tell them because that's client-attorney privilege.
Can we use a subpoena to get it though?
No.
No?
No. In states that permit polygraph evidence to be used in trials, judges conduct pre-trial hearings to determine whether polygraph results are admissible. And of course, that's in those third of the states. I looked it up, and they gave me a list of 47 states that allow polygraph tests. What does that mean? That means that most states will allow polygraph tests in select circumstances. And then they broke it down by state. California does this, Kentucky does this, Indiana does this. So all the states have different laws. It really all depends.
Does Arizona?
I'm sorry?
Does Arizona?
Arizona was one of the states on the list. I didn't read Arizona's.
That allows it?
That allows in certain circumstances. Develop a breathing, okay, so this is how you beat the polygraph test. Are you ready for this? Develop a breathing strategy by altering the rate of breathing during relevant questions and comparison questions. Because that's one of the things that they're reading. They're reading your heart rate. So if you breathe the same rate on your comparison questions and the relevant questions, then it's not going to detect anything. Do complex calculations in your head. If you're thinking of something else, then you can't indicate to the polygraph that you're lying. Okay. And this is, remember we're talking about asking irrelevant questions. They're trying to get you to relax, and then they'll pop a relevant question in there. This is a interrogation technique. So one of the things you can do is you can think about something else. If you're doing math in your head, of course, you're thinking about finishing the math problem, but at the same time, you're answering this question. So that is interspersing with this other information. So it's giving them erroneous results. Prior to the test, rub antiperspirant on your fingers and palms. Remember, they're looking for sweat on your palms. It's one of the things, so you can rub antiperspirant on your palms. You don't really have to do that. All you have to do is put antiperspirant on in your armpits, and you can rub your armpits, and you'll get antiperspirant on your hands. How about that? Insert a small tack, and this is what I was talking about before. If you insert a small tack into your shoe and press it on it during a comparison question, then it will give them erroneous results. It'll look like you're innocent, and you may be guilty. So there you go. You can control your breathing. You can do math in your head, or you can and put antiperspirant on, or you can insert that tack into your shoe. Okay, so we know the polygraph test is only about 65% accurate. However, that's not the only means that they have of looking at your brain. Neuroimaging in deception detection, techniques such as functional magnetic resonance imaging, functional MRIs, use scanners to measure blood flow and oxygen utilization in select parts of your brain. Different patterns of brain activation have been shown to be associated with truth-telling and lying. The accuracy of this method ranges from 76% to 90%. Now there's a problem with this. This is what an MRI machine looks like. Okay, we're going to take our suspect. We're going to lock his head into this this structure here, and then we're going to shove them into that machine. And then we're going to start asking them questions. I don't think so. They haven't really done this with criminal cases, only in research. and they've found it, that it is about 76% to 90% accurate, which is fairly high. It's much higher than the polygraph test at 65%. The problem is the structure. However, they have a portable one, and that's what it looks like. So we can strap this sucker on somebody's head and try to get the same information. Despite lingering concerns about the validity of its use under varied conditions, functional MRI techniques are being marketed commercially and are occasionally used in court, but not very often. One of the problems is the court is relatively slow. It took them forever to accept the polygraph test. Then it took them forever to get rid of the polygraph test. It's taking them forever to accept the functional MRI. Functional MRIs have only been around for about 20 or 30 years. It's been used in psychological research, but it's not really used in a court of law. And of course, it has to be accepted by somebody before the other courts will accept it. And of course, once it is accepted in one court, maybe in Mississippi or Alabama or whatever, then somebody will take it to the Supreme Court and find out if they can be used in a court of law. That's the way it works. Brainwave analysis is another way to do things. Brain fingerprinting uses the EEG to record the brain's electrical activity. Brain's fingerprinting evaluates neural activity to assess how a suspect responds to crime scene details known only to the perpetrator. So they start asking them about a crime scene. If they are the bad guy, then of course they will have a different brainwave because they will have different knowledge than somebody who has no knowledge whatsoever. This is 85% to 95% accurate. It will distinguish liars from truth tellers in the lab. It works in the lab. Near chance levels in the field, of course, doesn't really work with criminals, but we can use it in the laboratory, and it works. Will we ever get one of these things to use in Shinley, the Navajo Nation Police? No, probably not. Defendants and witnesses may try to introduce the results of these tests to demonstrate their innocence or bolster their capability or their credibility, whether they're using a functional MRI or whether you're using the EEG. That's another question. Legal issues arise with regard to brain-based techniques, especially when these techniques are conducted against the wishes of the subject being scanned. Of course, you're not going to be able to lock them in a functional MRI machine and get them to incriminate themselves. Do you have to take a polygraph test? Do you have to have a functional MRI? Do you have to have an EEG? No, you don't. Can the court order you to do it? And the answer is it has to be voluntary. And the answer really is, if it's not voluntary, it's not going to be accurate anyway. Should these practices be governed by the Fourth Amendment prohibition against unreasonable search and seizure? And of course, that's where we are right now. The court just made a decision yesterday as far as defendants' rights are concerned. The Supreme Court made a decision yesterday. I'm trying to think what it was. And actually, the new member of the Supreme Court went with the liberals on the court. He's a conservative, but he went with the liberals. So it's really kind of interesting that the court is split. It's split 50. It's split 5-4 in favor of the conservatives, but there are conservatives that vote with the liberals from time to time. And he voted with the liberals. So they are defending people's rights. It looks like they're defending people's rights. Many urge judges to resist admitting this evidence until more conclusive data are available. Of course, this is all experimental, and judges don't have to accept it if they don't want to. Once one judge accepts it, then another judge can accept it, using that as its as the precedent. And then, of course, the state Supreme Court has to decide whether it's accurate or not. Once the state Supreme Court accepts it as accurate, then they will take it to the federal Supreme Court to see if this has become a precedent around the United States. Okay, so that's the electronic means of determining if somebody's guilty or innocent. Sometimes people confess. When police capture suspects, one of the first acts is to encourage a confession. And they will do this. Just confess. You know you had that bag of marijuana in your car, and it wasn't your cousin that put it there. It wasn't somebody broke into your car and put all that incriminating evidence in your car. You know it was you. Just confess. And it will go lighter on you because we won't have to have a trial. Trials are expensive. And trials piss people off. So the judge will throw the book at you unless you confess. A confession permits a district attorney or a grand jury to bring charges. If the suspect later recants, the confession can be introduced into evidence at the trial, depending on which state you're in. Many false confessions have been documented, although the number of false confessions is actually a matter of contention. Of course, the question is this a false confession or a real confession? Until the mid-20th century, many confessions came only after intense questioning that involved promises, threats, harassment, and even brutality by the police. This is not in the United States, of course. We don't usually use water to try to get people to confess. As you can see, he's handcuffed, and they're squirting water directly into his face. A pretty heavy stream of water. I'm not exactly sure. I think that's Thailand, if I'm not mistaken. Until 1966, the traditional test for admissibility of a confession was voluntariness. A voluntary confession is given without overt inducements, threats, promises, or physical harm, but voluntariness is difficult to assess. How voluntary was it? Is this a voluntary confession? He's got a hold of the hair on the back of his head. How voluntary would that confession be? Well, according to the police, no matter what he was doing to the guy, it was still a voluntary confession. The reality is that you can't convict anybody without evidence. So where in the world do you get the evidence? If you can't find it at the crime scene, you're going to have to get the suspect to confess. Otherwise, you're not going to get a conviction. Do we know people that are guilty that were actually not prosecuted? Probably. Everybody thinks that O.J. murdered his ex-wife. Not everybody. A lot of people think that O.J. murdered his ex-wife. Books have been written about it. He wrote a book, but he didn't confess. So was he guilty? Is he guilty? Was he guilty?
He was found not guilty, right?
He was found not guilty. There wasn't enough evidence to convict him.
The glove didn't fit.
If the glove doesn't fit, you can't convict. You have to have enough evidence to convict them. And if you don't have enough evidence, how can you possibly convict?
Can't you just use bluff
I'm sorry?
Can't you just use bluff techniques, like to say, oh, we have the evidence against them, and convince them that they're trying?
Can you lie to your suspect? Is that what you're saying?
Yeah, like little police do that all the
Oh
time.
yeah, they use it all the time. Of course you can. Does that mean that the confession is not accurate if it was a coerced confession? If you lied to
Well,
them?
they can be falsely guilty, feeling like they need to do it because of pressure by the police, that they're there for like 5 or 6 hours.
Good point. 1965, okay. So all this is taking place in the 1960s. What was going on in the 1960s? Early 1960s.
Peace, love, and war.
66, 60. Peace, love, and war. Okay, we've got peace, love, and war going on. Is anything else going on in the United States? I'm sorry?
Racial profiling.
Racial profiling? It's worse than racial profiling. Civil rights movement was going on. Okay. So we got all this, all of a sudden people care about the police because there's riots in the street. And the riots started in like 1963. Then in 1964 there was another riot. This one was in Newark, New Jersey. First riot was in Watts, Second riot was in Newark, New Jersey. There was a riot in Cincinnati. There was a riot in Detroit. There was a riot in Chicago in 1968. Oh my goodness gracious. All this stuff is taking place. Nobody even thought about the police. Nobody even cared about the police. And then all of a sudden we started having this social unrest. And of course the anti-war movement started about this time. Well, of course you had to have war in order to have an anti-war movement. It didn't start until the middle 60s, like 65. So all of a sudden we get all of these interesting laws. Wait a minute, I'm going the wrong direction. Okay, yeah, we're getting all these interesting laws. 1966. So voluntariness, and of course we never even thought about this before, but all of a sudden we've got all of it, and what is it? What is it that is causing us to care about the police in 1966, 1965? We've got the civil rights movement going on, we've got the anti-war movement going on, so all of a sudden people start caring about the police. Why? Before that, only, police did whatever they did to criminals. They were trying to protect us. All of a sudden, we've got everybody cares about how the police are treating people. Why is it? You could beat the holy hell out of your suspect, and nobody cared before 1965. So what happened in 1965 that made people care?
Did they end up killing protesters?
I'm sorry?
Did they end up killing protesters because they were being too brutal on them?
Yeah, they were killing protesters, but that's not that big a deal. Come on. They're bad people, right? Aren't they? Aren't they bad people? It's okay to kill bad people. As long as you're killing bad people, you're all right. But who were they arresting? Were they suddenly arresting in 1965 that they weren't arresting in 1955 or 1945? 1951, they rounded up all the Mexicans they could find and they sent them back to Mexico. They arrested them, threw them in jail. It was called Operation Wetback. And I know, isn't that horrible? How many people in the United States cared? Hardly anybody. It's in your history book, but wow, you have to find it. Look up Operation Wetback. It's like 50-51. This is Harry Truman. He was a liberal. What's going on? You know, crazy stuff. So not only did they were looking for illegal aliens, but they just arrested anybody that looked Hispanic and sent them back over across the border. Some of these people were American citizens, and it took them a long time to get back. Nobody cared. I know. So what happened in 1965, 1966 that made people care? They did all that stuff to they did that stuff to the Mexicans, and then in the early 1950s, they were arresting black people willy-nilly throughout the 50s into the 60s. Nobody cared. So all of a sudden in 1965, 1966, we start getting new laws to protect the suspects. So what happened in 1965, 1966?
Miranda rights?
I'm sorry?
Miranda rights?
Yeah, Miranda rights, but where did it come from? And why did people suddenly start caring in 1965, 1966?
Voting rights?
Voting Rights Act was passed in 1965. That's black people again. We've already proved that we didn't care. I mean, they were lynching people in the United States. And nobody raised a finger. So what was going on in 1965, 1966 that made people care? Who are the most important people in the United States? White people. And who are the most important people to those white people? Their children are. And it was their children that started getting arrested. So they wanted to make sure that the police weren't going to beat their precious princesses and princes. They started protesting against the war, and they started protesting for civil rights. People have been protesting for civil rights since forever. But nobody did anything about it until the white kids started protesting against civil rights. And they started getting arrested. And they didn't want their kids being beaten to death or hosed down with water like they were doing to the black people. Nobody cared. As long as it's black people, nobody cares. We arrest all these Hispanics. Did you look up Wetback? Operation Wetback? Does it give you a figure as to how many people were sent over the border? I'm sorry?
They gave photos of it.
Photos, okay. Arresting Hispanics. All you had to do was look Hispanic. You know, do you have any papers? Do you have a green card? That's what they were asking them.
Like a lot.
Does it give you a number? Oh, you're just looking at pictures. You need to read it. Yeah, look at that. They arrested them. They incarcerated them and sent them back across the road. Yeah, you just keep going. Yeah, there you go. Okay, Operation Wetback. Don't write that. Sounds too racist. It was racist. Of course it was racist. It was in the early 1950s, like 50-51. Anyway, and nobody cared. Nobody cared because they were a minority. A lot of these people were illegal. Some of the people were illegal. Well, most of them, if they sent across the river, were illegal. Some of them weren't, though. 1966, Miranda versus Arizona. It happened right here. The Supreme Court held that a confession resulting from an in-custody interrogation was admissible in court only if, in addition to being voluntary, it had been obtained after the police had ensured the suspect's protection from self-incrimination by giving the Miranda warnings. The Supreme Court extended those rights to juveniles in 1967. But we're going to find out that the people that are the most affected by confessions are juveniles because they don't understand their Miranda rights. Many suspects waive their Miranda rights, and after a suspect voluntarily enters the interrogation room, investigators can use various tactics to obtain a confession. Anything is legal as long as they don't touch them, as long as they don't. They can coerce them. Sure they can. They can tell them anything as long as they don't touch them. Those who are young or mentally disabled are especially vulnerable, of course, because they don't understand. 90% of juvenile suspects waive their Miranda rights, as odd as that sounds. Supreme Court has stated that judges should take into account a minor's age when determining whether he understood that he was in custody and deserved to be read his Miranda rights. Okay, if a policeman arrests you, they have to give you your Miranda rights. But if they don't arrest you, they don't have to give you your Miranda. They don't have to tell you what your Miranda rights are. So they can take you into the interrogation room and not give you your Miranda rights because you haven't been arrested. Okay, we're going to talk about this in a second. This is kind of bizarre. Miranda survived a challenge in 2000 when the Supreme Court reaffirmed that Miranda was a constitutional ruling that the warnings are part of the national culture. In other words, everywhere they have to give you your Miranda rights. Every place in the United States. This is a constitutional right that you have in the United States. So that's what they have to do. They have to read you your Miranda rights. Not just in Arizona, not just in Montana, but everywhere. Everywhere. And if they're going to arrest you, they have to read you your Miranda rights. This is an example of stare decisis, the court's preference for maintaining stability in the law. And that's what it means. Stable law, stable decisions. Stable decisions is what it means. The U.S. Supreme Court has weakened the Miranda requirements. Confessions that violate Miranda may still be used at a trial, and this was upheld in New York versus Harris in 1971. Miranda doesn't apply unless a suspect is in police custody. So you don't have to read Miranda rights to somebody that you're interrogating unless they're arrested. Miranda doesn't apply unless a defendant is being interrogated. as a defendant, as somebody that's been arrested. You can bring people into the interrogation room without arresting them, and then you don't have to read them their Miranda rights. Two kinds of erroneous outcomes are possible: false denials when the guilty suspect proclaims their innocence, and false confessions when innocent suspects confess to alleged crimes. Now, why would somebody who's innocent confess to a crime that they didn't commit? It happens all the time, and it's really kind of bizarre. Oh, there you go. Between 1966 and 2007, there were approximately 250 documented false confessions in the United States. False confessions were involved in 15 to 20% of cases in which DNA evidence led to exoneration. So the individual confessed despite the fact they hadn't committed the crime. Proving a confession is false, there are 4 ways in which we can be certain that a disputed confession is false. First of all, a suspect could confess to a crime that never happened. That's possible. It was physically impossible for the suspect to commit the crime. They were in California and the crime was committed in Colorado. It was impossible, physically impossible for them to go from one place to another so rapidly. The actual perpetrator is identified with guilt objectively established. So somebody else has already been, they've found evidence that somebody else committed the crime. There is evidence, such as DNA evidence, that definitely establishes the defendant's innocence. So he claims that he raped somebody. They have a DNA sample from the semen, and it's not his. So despite the fact that he's confessed, he can't possibly be the person that was the rapist. So DNA evidence exonerates him. But people still confess, strangely enough. When a suspect arrives at the police station for questioning, the police begin to subtly exert pressure on him or her to talk. The interrogator may try to soften up the suspect by using flattery, ingratiation, and rapport building, asking benign questions and engaging in pleasant small talk. They're trying to get the person to relax. If they get them to relax, if they are trying to think of a lie, it's harder to think of a lie if they're thinking about something else. And of course, that's what they're trying to do. They're trying to get them to think of something else. They're trying to tell them how smart they are. And if they can convince them that they are smarter than, that the suspect is smarter than the interrogator, then they are more likely to, of course, spill information that they didn't mean to disclose. The police are required to give the Miranda warnings prior to questioning, but there are ways to circumvent this. Warnings are required only when the suspect is being interrogated while in custody, so police sometimes tell the suspect that he is not under arrest and is free to go, so there is no need to warn him. Unless he is arrested, then they don't have to give him his Miranda rights. So if they just bring him in for interrogation, a select individual, they don't have to read him his Miranda rights. He doesn't have to incriminate himself. He can have a lawyer present. That's what Miranda tells you. You can have a lawyer present. You don't have to incriminate yourself. You can plead the fifth, in other words. That's what Miranda says. But if they're just being interrogated, you don't have to read them their Miranda rights. Sometimes the police will minimize the importance of the Miranda warnings by describing them as a mere formality. If anybody reads you your Miranda rights, that means you're under arrest, or they're planning on arresting you. But if they don't, then you're not. And you can go, you can leave anytime you want. I know, that's something people don't understand. But you can go anytime you want. When Miranda warnings are provided, almost all suspects waive their rights and talk to the police. Strangely enough, despite the fact that they read their Miranda rights, people still waive their right to counsel. They waive the right to not incriminate themselves. We already saw that 90% of juveniles waive their Miranda rights. The police will use negative incentives such as accusations, evidence fabrications, attacks on the subject's denials to break down the subject's defenses, lower his or her resistance, and instill feelings of fear, despair, and powerlessness. So you can lie to them, and that's an acceptable technique. You don't have to tell them the truth. You can say you have evidence that you don't have, that doesn't exist. I know. The police also use positive inducements to motivate the suspect to see that an admission is in his or her best interest. The longer we drag this thing out, the harder it's going to be on you. Usually that's what you say. This is so hard on your family. Why don't you just confess, and the mystery will be over with, and people will stop suffering. Or they will, they'll tap into people's empathy. The family needs closure. If people admit this, then they can get closure. And of course, they will feel better about what's going on. We can bury the dead. We don't have to hold the body. We can release the body for burial. You know, all that kind of stuff. After the suspect has implicitly or explicitly agreed to talk, the interrogation becomes accusatorial. Interrogators frequently challenge the denials that suspects make. Interrogators present fabricated evidence. Even if interrogators have no evidence of suspect wrongdoing, they can make them believe that they do. And this is legal. So is this coercion, is the question. I know, coercion is a legal term. Is it coercion? No, it's not coercion. It's not entrapment. I know, this seems kind of weird, doesn't it? Those are both legal terms, and no, this isn't entrapment, it's not coercion. An empirical look at interrogation tactics: innocent people are more likely than guilty people to waive their Miranda rights. Okay. And police will tell you that. If you waive your Miranda rights, you look more innocent. And they will tell you that. Why won't you talk to us? Now you're innocent, so you have nothing to fear from us. We're not going to use any we can't use any trickery to get you to confess. We can't do that. It's illegal. We can't do it. The detective's presumption of guilt can lead to behavioral confirmation. And this is the problem. If they arrest somebody that they think is guilty, then they may not look for anybody else. And this is known as behavioral confirmation. The detective will seek out information that verifies their beliefs. They'll overlook conflicting data, and they will behave in a manner that conforms to that belief. So they're looking to make this individual guilty. So they have a prejudice against this select suspect. And we see this all the time in the police. Now, one of the things we found out about the police in the earlier chapter is that their intelligence level isn't all that high. We're not talking about all the geniuses become policemen. But the television shows are about geniuses who become policemen. Monk. I don't know. All these people become policemen, but the reality is that their intelligence level may not be that high. So they may focus, they may obsess on one select suspect, and they may not look for another one. If they get the wrong suspect, if they arrest the wrong person, and they decide that he's guilty, are they going to look for somebody else? For the person that actually did it? And we've seen this over and over and over again. This is what happened with Ted Bundy. Ted was pretty. He was charming. So they kept arresting other individuals as the person that committed this crime. They couldn't tie all of these things together, all these rapes and murders. there was a similar modus operandi. But they didn't want him to be the guilty party because he was too pretty. Pretty people don't murder people. That's the way it works. Oh, man. Many juveniles have difficulty understanding the rights accorded to them by the Miranda warnings. Of the 125 proven false confession cases compiled by Drizin and Leo, 33% involved juveniles. So juveniles don't really understand the Miranda rights. Juveniles, of course, are underage. They've always been protected by their guardians, whoever their guardians may happen to be, their parents or whatever. So, and they've always been treated differently. But of course, adults are treated in a different manner, so they understand some of the negative things that can potentially happen to you. Juveniles don't always understand this, especially ones that have been relatively spoiled. And of course, we always try to spoil our children. Kasson and Reitzman in 1985 devised a taxonomy to describe 3 kinds of false confessions: voluntary false confessions, compliant false confessions, where the suspect complies with the interrogator's demands to make an incriminating statement, all the while knowing that he or she is innocent, and they just do it because that's what they think the interrogator wants. So they confess to it, just to make the interrogator happy. And the third is internalized false confession. As a result of manipulative interrogation, suspects confess because they have come to believe that they have actually committed the crime. They have been convinced by the police that they have committed the crime. I know. They didn't do it, but the police have convinced them that they did. Gee, I wasn't there at that time, but I guess you're right. I must have been the one to pull the trigger. I didn't have a gun, but I must have been the one to pull the trigger even though I didn't have one. I must have been the guy. Many prosecutors assume that only guilty suspects confess. And in most cases, that's true. Most people will not confess to something that they didn't do. So they tend to treat confessing suspects harshly. They request higher bail for these select individuals. Even defense attorneys assume that people who confess are guilty and urge them to accept plea bargains rather than risk their chances in a trial with confession evidence. Remember, we talked about the guy that was convicted of rape, and they offered him a plea bargain. And instead of taking the plea bargain, he said, "No, I'm innocent, and I will fight this." And he was in prison for 30 years because he wouldn't take a plea bargain. He could have gotten out in 10. But instead of getting out in 10, because he was innocent, he wouldn't take the plea bargain. He wouldn't admit that he was guilty. And of course, this is a potential problem. In cases of disputed confessions, judges almost always decide that confessions are voluntary and thus admissible, even though it doesn't look that way. Even though it's not true. It's a false confession. But they feel that almost all of them are voluntary, and therefore they allow them to be admissible in court. Jurors are very influenced by confessions. Jurors are highly likely to convict defendants who have confessed even when the confession is false. Cases in which false confessors pled not guilty and proceeded to trial show that jury conviction rates range from 73% to 81%. So if there is a confession, they almost always convict, whether it's a false confession or not. So don't confess, even if you just made it up. Jurors fail to discount a confession elicited by high-pressure tactics of interrogators, and of course this is due to the fundamental attribution error. They do not see the external situation as a detriment of behavior. In other words, it was coerced, even though it was coerced. Even though he was physically intimidating, they don't see that as a problem. People will not confess to things that they didn't do. All confessions are voluntary, and we see this over and over again as far as false confessions are concerned. Recording all police interrogations can provide a complete, objective, and reviewable record of how the suspect was questioned. We're doing that with, we've got body cameras now for police. And the reason we have body cameras for police, we never had them, well, sometimes we had them in cars. But now we have body cameras on the police, so if they shoot somebody they shouldn't have shot, that we will have evidence about dealing with that. Albuquerque has just started pinning cameras on policemen. This is the second year that they've had them, and last year they had a body camera that evidently didn't work very well. And now they have switched body cameras. Why is that important? Well, they could turn the other ones off, and these they can't turn off. Okay. And they're also like $2,000 more expensive than the other ones. So everybody's up in arms. Yes, we do want our police to do the right thing. We need that evidence, but we don't want to spend any money for it. Okay. So one of the things we can do is we can record all of these interrogations. Recording can deter manipulative tactics by investigators and frivolous claims of coercion by defendants. And of course the defendant will say, yeah, I was coerced. Can't you see this? They held me in there for 3 hours. They didn't let me have water. They wouldn't let me go to the bathroom. I wet myself while I was sitting there. I was coerced. I know, okay. So, but if this is all recorded, then of course they can't say those kinds of things. A handful of states require videotaping, and a growing number of jurisdictions voluntarily record all interrogations. As odd as that may seem. These two states, New Mexico and Arizona, are not two states that require interrogations to be recorded. Note that Lassiter and his colleagues in 2009 found that when the camera is focused on the suspect, and if you can see all of these interrogations, the policeman is here, and the suspect is the one that we're looking at her face. We're not looking at the interrogator's face. Found that when the camera is focused on the suspect, observers are more likely to judge the confession as voluntary, compared with the same confession recorded from a different camera perspective. So if it's showing both the faces of the interrogator and the suspect, then they're more likely to see coercion as part of the interrogation technique. This is an example of an illusory causation, the tendency to attribute causation to one stimulus because it is more conspicuous than others. When the recording shows both the suspect and the interrogator, observers are more attuned to situational pressures exerted by the interrogator. If they're not looking at his face, they hear the questions, but they're not listening to the questions. If they can see his face, they can see him saying these words, then they're less likely to see the confession as voluntary. They see the coercion if they can look at the interrogator's face. You find this odd? Jeff's going, nodding his head yes. It is very strange. Another reform would be reconceptualize the fundamental nature of police interrogations. Researchers have found that non-confrontational UK-type interviews produce fewer false confessions and more true confessions than accusatory interrogations. In the United States, remember, we used to use torture techniques in order to get confessions. So we have that in our history. In England, of course, they use a different type of non-confrontational interviewing technique. It's an interview, it's not an interrogation. So they're asking them to tell their story. They still get confessions in England. If you've ever watched an English police show, and they do have them on television from time to time, you can see that their interrogation techniques are completely different than they are in the United States. Are these better? And the answer is yeah, but you don't get as many convictions. And of course, that's what we're looking for in the United States. We're looking to convict as many people as we possibly can. Anyway, okay. So the English do it a different way. Let me get out of here. There we go. Okay. Let's start on another chapter. Oh my goodness gracious. Let's talk about juries. Judicial prosecutions, arrest, bail, plea, negotiation, settlement, and trial. We're getting there. We're getting to the end of the road here. This is chapter 8. There's only 15 chapters. Will I get through all 15 chapters? I don't think I'm going to make it. You're going to have to read the last chapters yourself. Sorry about that. I know I won't be able to talk about this stuff. Many criminal cases are simply dismissed for lack of evidence or other difficulties that prosecutors perceive in the case. One of the reasons, if you ever watch cop shows, a lot of times they don't have enough evidence to prosecute. A lot of times they have evidence, but the prosecutor doesn't think it's enough. They try not to take cases to court. It's too expensive. They try not to take cases to court that they don't have enough evidence to convict. And of course, that's the job of the police, to collect that evidence. Now the problem is, of course, that they're looking for evidence to convict a select individual. What they actually should be doing is just collecting evidence and taking that evidence to find the right guy that committed the crime. That's what they need to do. But they can't afford to do that because it takes them all in too many different directions at the same time. So what they have to do is they have to accumulate evidence against a select individual. And that sometimes blinds them. It makes them myopic. They only see one bad guy. Or two bad guys. Or they're not looking at everybody. They're looking at a select individual, trying to prosecute that guy, trying to convict him. For the vast majority of people charged with crimes and not fortunate enough to have the charges dropped, plea bargains, not trials, resolve the case. These cases rarely go to court. Almost all cases are plea bargain. So they make a decision as to what is going to happen to this individual before they go to court. And if they plea bargain, of course, the guy will plea bargain in order to get the sentence reduced. I will confess to this, and that's what happened with the shooter at the Aurora, the theater in Aurora. He killed, what, I don't know, 25 people? He wounded 70. Shot a lot of people. But he tried to plea bargain with the prosecutor. Of course he's guilty. I mean, he had all this evidence against him. He's guilty, but he's trying to plea bargain so that they wouldn't execute him. And I think that's what happened. They're going to put him in jail for life with no possibility of parole. I think that's what happened. But he plea bargained them down. I mean, obviously, he killed so many people, he wounded so many people. He's guilty. So what is his punishment going to be? Somebody look that up. I know he tried to plea bargain. What did they convict him of? I can't remember his name. I remember he had orange hair. Who has orange hair?
Dennison.
I can't remember his name.
Dennis Rodman.
Right here, it's from.
Okay, if you're going to Google it, you need to Google Aurora theater shooting.
Oh, almost like Carrot Top.
Carrot Top, yeah, it's Carrot Top, that's what it is. I don't think they're going to execute it, despite the fact he murdered so many people.
James Holmes.
Holmes? Okay. Thank you, James Holmes. Okay, so look up and see what's going to happen to him. He didn't go to trial. He tried to claim that he was insane when he did it. Body armor. He had that drum. And I'd never seen one of those things. It comes from both sides. It's on a belt. I know. It's kind of hard to hold on target. Isn't it? You never fired.
The recoil.
Yeah, the recoil is pretty bad. The recoil is supposed to be backwards, but it's not. Some of it is up and down. I'm gonna look. Plea bargaining is a process in which the defendant agrees to plead guilty in exchange for some concession from the prosecutor, such as a reduction in the type of charge, the number of charges, or in the recommended sentence. A lot of times it will have to do with the prison that they go to. Is it a maximum security prison? Is it a minimum security prison that they go to? How much freedom will they have? Will they put them out in the general population, prison population? By pleading guilty, defendants give up their rights to a trial, of course. Most civil cases are resolved without a trial in a process called settlement negotiation. Now, if you talk to, and I hate to keep picking on the president, but he's been sued a lot, but he's very rarely been found guilty, or he's very rarely had to admit that any wrong. That's what he tries to stay away from. And the answer, or the question is why? You know, if this guy isn't paying, this guy's doing something for $100,000 and he refuses to pay him $100,000, he gives him $50,000 instead. So the guy, and he says, go ahead and sue me. So he sues him for $50,000. What happens next? So he's been sued. What happens next?
The case vanishes.
What happens next is they settle out of court. And if they settle out of court, he doesn't have to admit that he's guilty. Now, he may give him $100,000 in the settlement. So instead of paying $100,000, he paid $150,000. But at least he didn't have to admit that he was wrong. And this is one of the ways that he's been able to get away with this kind of stuff for an extended length of time. First of all, he's got really good lawyers, and second of all, he settles out of court. So he doesn't have to admit any wrongdoing. If the police believe that a suspect committed is anybody looking up Holmes to find out what his plea bargain was? Whether the plea bargain was accepted? Ernest, look it up. Not just pictures this time, okay? James Holmes. That was the guy's name. He is in prison right now. I think he is. I'm pretty sure he is, but he's not on death row. And Colorado does have the death penalty, if I'm not mistaken. They hardly ever execute anybody. If he'd been in Texas, they would have shot him already. They would have burned that guy. Texas has more executions than than all the other states combined. Congratulations, Jeff, who wears a Texas shirt all the time. We not only convict, but we also execute. Anything, James Holmes? He tried to plea bargain them down to life imprisonment rather than the death penalty.
James Holmes in prison.
Siri's going to give us the answer.
He was initially jailed at Arapahoe Detention Center under suicide watch. He is being held in solitary confinement to protect him from other inmates, a routine precaution for high-profile cases. Holmes made his first court appearance in Centennial, Colorado on July 23, 2012 before Judge William D. Sylvester.
So what is it? What's his sentence?
12 consecutive life sentences plus.
Oh, so he won. They accepted his plea bargain. 12 consecutive life
I
sentences.
don't know if this is right. This is 3,318 years in prison without possibility of parole.
There we go. Okay. That's all he wanted. He didn't want to be executed. So he plea bargained for life imprisonment. 12. I guess he killed 12 people. Okay. Interesting. Thank you. Arapahoe. You know where Arapahoe is? I almost got a job at Arapahoe Community College. It's south of Denver, just south of Denver. I know. I didn't interview very well. I didn't do a very good job. It's a huge campus. I mean, it's like twice as big as Denver. It's huge. If the police believe that a suspect committed a crime, they will probably arrest the suspect. Charging implies a formal decision to continue with the prosecution, and that decision is made by the prosecuting attorney rather than the police. So the police arrest, and then the prosecutor has to decide whether to keep them. If they don't have any evidence against this guy, they can't hold him. They have to let him go. The Fourth Amendment to the United States Constitution requires that any person arrested be brought before a judge within 48 hours of arrest. And of course, this is one of the things that we see. They have to go before a court. They will either come before the court or they will do it with closed circuit television. Sometimes they stay in the jail and they will televise the end of the court. The judge reviews the evidence summarized by the prosecutor and determines whether there is reason to believe that the suspect committed the crimes charged. So you can arrest somebody. You think that this guy committed the crime. You have 48 hours, the police have 48 hours to accumulate enough evidence to get the judge to hold them. You can only hold them for 48 hours. In those 48 hours, you're looking for evidence. And you need enough evidence to convince the judge or the prosecuting attorney that there is a reason to convict. The Fourth Amendment protects the people from unreasonable search and seizure. This means that the police must have a warrant to enter your home. It also means that the government cannot take your property, papers, or you without a valid warrant based on probable cause. So there has to be probable cause in order for them to arrest somebody. So in order to surveil somebody that you think is committing a crime, they can't just look at everybody in the classroom to find out if you're a criminal or not. They can't do that. They have to have probable cause. They have to have evidence that suggests that this person may have committed a crime. Now, if you're watching this whole Russian collusion thing, there was an individual that was working on the Trump re-election, or the Trump election campaign, that was being surveilled during the election. He was being watched. And the reason he was being watched, we find out now, was because they thought that he was a foreign agent, that he was working with another government. And actually he had worked for another government previously. So they were surveilling him, so they have all of this evidence from this guy that deals with collusion. Okay, so this whole thing may blow up, and it may turn out that there really was collusion. But they were surveilling him during the election process. And he didn't quit until 3 months before the election. So that during that whole time, they were actually watching him and listening to his telephone conversation. Remember when Trump tweeted that Obama had was wiretapping Trump Tower? Remember when he tweeted that? This is what he was talking about. And the guy's name is Paul Manafort. It's going to be just fascinating to watch the whole process. Aren't you fascinated by all this? No, you're not. You don't care. The judge will inform defendants of the charges against them, inform them of their constitutional rights, review the issue of bail, and appoint attorneys for those that cannot afford to hire their own. So the first thing they do is they tell them that they have rights. They tell them that they've been charged with murder or whatever it is that they've done, with robbery, whatever. They tell them their constitutional rights. They will decide whether they should give them bail or not. Remember, when in the last chapter we were talking about an individual that confesses. Their bail tends to be higher. If they have confessed, they tend to make it higher. They will appoint an attorney, of course, if they can't hire one themselves. They will appoint an attorney. So who pays that attorney's fees? If I go to court and I don't have enough money to pay an attorney, who pays the attorney fees? Attorneys don't work for nothing.
Does the state pay for it? The state?
The state pays, yeah, state pays. So how hard is he going to work at at defending his client? If he's a good lawyer, he'll defend him anyway. But, of course, if you hire him, if you give him money, then maybe he'll try harder. I don't know. This is an interesting situation. Prosecution must offer some evidence on every element of the crime charged, and the judge must decide whether the evidence is sufficient to pursue the case further. Okay, you've got a select amount of evidence. Do you have evidence to charge them with everything? That's the question. That's the real question. How many things can you charge this guy with? You can charge, well, in the case of James Holmes, we have 12 murders and 70 woundings. So what are you going to charge him with? Do you have evidence for all 12 of those murders? And the answer is probably no. You probably can charge him with 1 or 2 murders. And this is what happened with Ted Bundy. Ted Bundy had committed all of these crimes, but they only had evidence in a select number of them. So they convicted him for one thing or another. Al Capone was arrested. Al Capone ran gambling. He was a bootlegger. He ran prostitution rings. So what did they arrest him for? Prostitution. What law did they arrest him for?
Tax evasion?
Tax evasion. They only had evidence that he had evaded his taxes. He hadn't paid taxes on his illegal gains, is what they prosecuted him for. I know, but they only had evidence for that. They knew that he had murdered all these people. He was the one behind the Valentine's Day massacre, where he shot those 7 guys, machine gunned them all down. He's the one that ordered that to happen. But they didn't have any evidence to convict him. So you can only convict somebody with the evidence that you have. So they may have committed 15 crimes, but you only have evidence for one of them. You can only convict them of that one crime, despite the fact you know that they've done all this other horrible stuff. No jury is present, and defendants rarely testify or offer any evidence of their own. So usually they just say that they're guilty or they're not guilty. And normally they will say that they're not guilty, whether they are or they're not. They will plead not guilty. Because if they plead guilty, now the judge gets to decide what's going to happen to them. And of course, there is no trial, so there is no possibility that they will get off. The judge will sometimes send the case to a grand jury or reduce the charges, either because he or she believes the evidence does not support the level of crime charged by the prosecutor, or because of a plea bargain. A lot of times in a case where somebody has died, wait a minute, there was a case that came up yesterday. Some lady was drunk, and her ex-boyfriend was standing in the middle of the road, and she ran over him. She killed him. They wanted to charge her with first-degree murder because she didn't hit her brakes. She just ran right over the guy and killed him. They wanted to charge her with first-degree murder, but instead, they didn't think that they had evidence that it was premeditated. So instead of charging her with first-degree murder, they charged her with manslaughter, and that stuck. The case was tried yesterday, and it was in the paper. Well, actually, it was last week that they tried it, but it was in the paper yesterday. So they didn't have enough evidence to convict her of first-degree murder, despite the fact, vehicular homicide, the whole rest of it. Okay. So if they don't have enough evidence to charge them with everything that they've done, potentially, they only have evidence for some things, they can only charge them with what they have evidence for. And a lot of times the judge will decide how much evidence they have and whether it's prosecutable or not. Okay. So, and sometimes, of course, they will talk about this case before, and they will plea bargain at this juncture. You can plea bargain anytime. So the guy did commit a crime, but he will plead to a lesser charge if they will only send him to jail for 6 months instead of 5 years. That's how plea bargaining works. Popular Penn State coach Jerry Sandusky was able to avoid prosecution in Happy Valley. If you've ever been to Penn State, that's what they call the place where Penn State is. Until a 2-year grand jury investigation. It took a grand jury investigation, and they were looking at his case for 2 years. He was charged with 52 counts of deviant sexual intercourse, endangering the welfare of a child, indecent assault, the rape of several young boys between 1994 and 2009. Was this prosecutable? Well, he'd been doing it for what? I can't do the math. 6 plus 9 is 15 years. He was able to get away with it for 15 years because they didn't think they had enough evidence to prosecute it. So he did it again and again and again. He is now serving a 30 to 60 year sentence. Everybody knew. It was one of those little secrets. Everybody knew that these women were being molested in Hollywood. Everybody knew that these women were being molested in Hollywood. They've been talking about it for a century. How do you get in the movies? You have sex with somebody. That's how it works. This has been going on forever. Well, forever is 100 years, I guess. Ever since the movies. How do you get to be a famous actress? You have sex with the right guy. We've known that this has been taking place. They call it the casting couch. And then they've been talking about it forever. Now, I'm not saying it's right. I'm certainly not saying it's right. I think it's absolutely incorrect. It's something that should never have happened. But now we've got Harvey Weinstein, who is being accused of all these things that he probably did. But is it prosecutable is the question. That's the question. What evidence do we have? If he's alone in a room with a young lady and he does something to her, or like runs around naked, the one lady accused him of masturbating in front of him. Another lady accused him of chasing her around the room naked. Gwyneth Paltrow has come out saying that he tried to sexually assault her. Angelina Jolie. Is any of this stuff prosecutable? That's the question that we have to ask. Is he ever going to go to prison? Roger Ailes was doing the same thing at Fox News. So was Bill O'Reilly was doing the same thing on Fox. Should they have been prosecuted? Could they prosecute them? I'm not saying it's right, I'm saying it has to be prosecutable. They need evidence in order to do this stuff. I know that Jeff murdered Brian. I know it. He did it. I know he did it. But I don't have any evidence to show that he did. And if I don't have any evidence, I can't accuse him. Because he can sue me for false accusations, despite the fact I know he did it. By God, I know you did it, Jeff, you monster. Poor Brian. He's everybody's favorite person. You just cut his head off with a samurai sword. Who in this room has a samurai sword? Jeff's the only one. No, there we go. Andrea has one too. Maybe it was Andrea, maybe it wasn't Jeff. But Jeff's sword, well, no, we don't have any evidence, do we?
Because I alibied him too.
Yeah. Will somebody alibi Andrea, please, before we leave the class? I guess it's almost time to go. Okay, so you need evidence.
She was with us too.
If you don't have evidence, you cannot prosecute. I apologize for that. It's not my fault. I think the guy's a jackass.